Good afternoon, ladies and gentlemen. Once again, I bring you very warm greetings from the Secretariat of the East African Law Society. We are once again live for another session of our capacity building sessions. My name is Gabriel Achai, and I serve at the Secretariat. I'm joined with my colleague, Berna Ishimwe, who is online. I would like to welcome you all and extend our gratitude to you for accepting our invitation. Today's topic is quite an interesting topic of discussion. It is one that is unique and one that has not been explored exponentially within the region. And this topic is on empowering women in arbitration. It's done in collaboration and partnership with the Women in Arbitration Initiative. And on our platform this afternoon, we have quite experienced ladies with very rich portfolios, very great level of expertise in the room by the moderator. But allow me to today is Miss Ellen Mugume. Miss Ellen Mugume is an advocate of the High Court of Kenya and Uganda. She currently works at the Sexual Reproductive Health Rights Alliance of Uganda. I hope I got that right. And it's my profound honor now to hand over the platform to Ellen. And Ellen, if you can hear me, over to you. We are all yours. Take it away.
Thank you so much, Gabriel. Thank you. Well, good afternoon, everyone, ladies and gentlemen. I welcome you all. Thank you for choosing to be part of this platform. Thank you for choosing to be part of this capacity building session. I have been introduced. I am Mugume Ellen, and I'll be your moderator today. This webinar is coordinated and organized by the East African Dispute Resolution Committee in partnership with the Women in Arbitration Initiative. The topical issue today is empowering women in arbitration. And for us to gain more insight on this topic, we have a panel of experts who are going to dive deep into this topic. Our panelists will discuss how women can be empowered in arbitration, the existing barriers, how the barriers can be broken, and how the future of arbitration looks like in our region. Ladies and gentlemen, feel free. We will take 2 hours in this space. Every panelist is given 10 minutes to present, to express themselves. There can be changes on that. It is really important that we hear from new participants, so we feel free to drop your questions in the chat box as presentations go on, indicating to whom your question is directed. And your take on this topic will be very welcome, especially in the chat box. These questions that will be dropped in the chat box will be answered during the question and answer session. I thank you. I have a panel of experts. I am thrilled, I'm excited to introduce them to you. We have Miss Madeleine Kimei. Miss Madeleine Kimei. Miss Madeleine Kimei is a founder and principal director of iResolve. She is an advocate of the High Court of Tanzania. She has over 15 years experience as a corporate and commercial counsel, arbitrator, commercial mediator, adjudicator, and dispute resolution specialist. She specializes in providing corporate and commercial legal support, representation in domestic and international arbitration, commercial mediation, and provides for dispute management advisory services. She has acted as a sole arbitrator, co-arbitrator, and presiding arbitrator in ad hoc and institutional arbitration proceedings under different platforms. Ladies and gentlemen, that is Madeleine Kimei, one of our panelists. We have another panelist called Edith Twina-Masiko. Edith Twina-Masiko is a founder of Women in Arbitration Initiative and an advocate of the High Court of Uganda with 7 years of experience in the field of law. She possesses a strong academic background, including a postgraduate diploma in law, legal practice, and an LLB honors degree, and is currently pursuing a Master's of Laws. Edith is also affiliated with the Chartered Institute of Arbitrators UK as an associate member. She is an active member of various legal societies, including the Uganda Law Society, Kenya Society, and East African Law Society. Within the Uganda Law Society, she's engaged with arbitration and construction clusters. Notably, you should get to know that Edith has taken on significant roles such as becoming the regional co-chair and advisory member of the Young ITA at the Center for American and International Law. She's also a committee member for alternative dispute resolution within the East African Law Society. Welcome to Twina-Masiko, Edith. We have on our panel Dr. Teresia Charles Numbi. Dr. Teresia Charles Numbi holds over 9 years of practical experience in lecturing at Tumaini University, Dar es Salaam College, specializes in local content compliance law, international trade, and investment laws. She serves as a seasoned facilitator and trainer at the Law School of Tanzania. She is a co-founder and CEO of Lighthouse Legal Clinic and holds the position of managing partner at Trian Attorneys. Dr. Numbi is a member of training committee of the Tanzania Institute of Arbitrators and an associate member of the Tanzania Institute of Arbitrators, a facilitator of Tanzania International Arbitration Center, accredited mediator and arbitrator, and an advocate of the High Court of Tanzania and all the subordinate courts. You're welcome, Dr. Teresia. We have another panelist, Ms. Aida Juma, a managing partner at Rumbea and Company Advocates, and leads the sector of financial services. She has 11 years of experience in litigation, arbitration, and legal services, acquired through assistance of numerous cases before courts and tribunals of Burundi. Ladies and gentlemen, that is Ms. Aida. You're welcome. We have our last panelist. That is Eunice Lumalasa. Eunice Lumalasa is a trial advocate, practicing arbitrator and mediator, accredited by the Mediation Accreditation Center, and an international arbitrator and mediator. Kenya's representative at the International Center for Settlement of International Disputes, Washington, DC, member Public-Private Partnerships Petitions Committee, and the Advocates Disciplinary Committee of the Law Society of Kenya. She is listed in the Kigali International Arbitration Panel, the Nairobi Center for International Arbitration, and listed in the Neutrals panels for the Delos Arbitrator Database. She is an advocate of the High Court of Kenya, tutor and trainer accredited by the Chartered Institute of Arbitrators London, a qualified patent agent, commissioner for oath and a notary public, and founding member and chairperson of the Women in Alternative Dispute Resolution, recognized for legal excellence and contribution in ADR practice by the Law Society of Kenya. You're welcome, Ms. Eunice Lumalasa. Thank you. That is our panel. And I welcome you all, dear participants and our panelists, to this insightful discussion. To begin with, because we need to catch up with time, we will allow our panelists to take us through this session. We will begin with Miss Edith Twinamasiko, who will take us through the general overview of arbitration practice in her region. You're welcome, Edith Twinamasiko.
Thank you so much, Ellen. Thank you. Just allow me to share my screen. You'll confirm if you can see it, and then we can begin.
Yes.
Okay. All right. Thank you so much. So, thank you for the kind introduction, Ellen. Just to start off, when Gabriel approached me for this partnership, I really did not imagine the attention it would spark. So thank you for taking interest in this session, and I hope us, the panelists, will give you the presentations that you expect, yeah, in regards to this, and as well as the answers to your Q&A. So just to introduce the initiative, we came together and formed this community as a result of, we noticed, first of all, few ladies in this space, and then second, the same ladies were taking up this space, or even no ladies at all. This space, I mean leadership space, yeah? So we came together and formed this community to support each other and empower each other to higher leadership standards. Leadership standards like Madeline Kimei, who's the president of the Tanzania Chartered Institute of Arbitrators. So the initiative came together this year, and it's based in Uganda, but it's regional really. And we keep in touch with each other via the WhatsApp group. If you're interested, I'll post the link in the chat. So just to introduce the initiative, our vision is really to create an environment where ladies take up these leadership spaces and also advance the practice of arbitration. So our mission is to promote and support these women, yeah? And our values, of course, inclusion, promoting diversity, empowerment. We seek to empower these women, and we know we can empower ourselves. Excellence, we seek to have excellence in this arbitration space, and collaboration. I mean, partnerships are very important. That's why we partnered with East African Law Society to bring you this session. Yes, and we hope we can gain more knowledge from it. Innovation, we embrace innovation in this arbitration space, and of course, advocacy. So just to go through our objectives briefly, we promote the meeting of these professional women in the practice. We want to meet more. We want to get to know them and also advance their interests. We want to create this international and regional network. Region, I mean the East African region. International, yes. We want to raise awareness about the role of women. Let's take up these leadership spaces, and which I know we are capable of. I mean, you find women with these big CVs, yes, but they are home unemployed. That's unacceptable. So us as a community, we're going to empower ourselves and lift ourselves to higher positions, really. And also we want to assist in professional development. So if you want to train for arbitration, there's we have info sessions that we organize to tell you how you can train, and above all, I think mentorship as well. So we have mentorship series starting next month for the community of ladies, and also we have a WhatsApp group where we share information, latest information, and latest activities that we're going to partake in. So those are objectives. These are our activities. We do carry out research and see how we can push this agenda of ours. Partnerships, again, starting with this one that we've had with the East African Law Society, that will give us more perspective and knowledge from other ladies in the region. Yeah, I'm so glad for the strong panel that we have today. These are ladies I think I've looked up to for a long time. So I'm so glad that they are part of this panel, and I hope they can be part of our mentorship series. and awards, recognition and awards. We plan to have annual awards for women in arbitration. This will encourage ladies to train and be active in this practice. So, okay, that's briefly how the initiative came together. So I'll just briefly define arbitration and give the overview of arbitration in Uganda. So I'm sure most of us know arbitration is used to resolve disputes outside the traditional court system. So parties submit their disputes to neutrals who are known as arbitrators, and then these neutrals review the evidence and make binding decisions known as awards. So what is the advantage of arbitration? There's flexibility, they're faster than the normal litigation, and there's confidentiality in the sessions, really. So some of the cases that can be used, arbitration can be done in the following scenarios, like commercial matters, international trade disagreements, construction conflicts, labor disputes. However, there are some matters which really cannot be handled using arbitration, like tax matters, matrimonial matters. So then we go to the law governing arbitration in Uganda. The act that governs arbitration in Uganda is the Arbitration and Conciliation Act of 2000. But the act that preceded that was the Arbitration Act, Cap 55. Now, of late, Uganda has attracted a lot of foreign investment. So we also closely aligned with the United Nations Commission on International Trade Law Model, as well as its rules. Yeah, so that is, in summary, the law governing arbitration in Uganda. So we come to the body that is responsible for appointing arbitrators. So ICAMEC, which is the International Center of Arbitration and Mediation in Kampala, is the one parties refer to when they want arbitrators to be appointed for their matters. So ladies and gentlemen, if you have qualifications, you can apply to ICAMEC and you're listed on the panel. However, there's a disclaimer there. You being listed on the panel does not mean that you'll be appointed by the parties as an arbitrator. So because one of the principles of arbitration is party autonomy, and the parties have their choice of who to choose as an arbitrator. So in a way, also diversity is being dictated by the party. So what I would say here is, ladies, let's brand ourselves. Let's put ourselves out there. If there's a speaking engagement, let's say we want to moderate. Let's write articles. I got some feedback from Uganda Law Society that they ask ladies in arbitration if they want to speak or moderate, and they say no. But we hope with this community, we can change that. We can encourage public speaking and taking up these spaces. So I just have a few statistics here. Regional statistics on gender. And as of March 2023, Kenya had 70. I beg your pardon. Out of 30 chartered arbitrators in Kenya, only 4 are ladies. Yeah. So I hope we have fresh statistics on that, but that was of March 2023. And then Tanzania is not any different. Of the 277 members of the Chartered Institute of Arbitrators, only 74 of them are women, and only 3 of them were on the panel. Same goes for Rwanda. With the arbitrators who participated, only 14 in arbitration sessions, only 14 were males and 4 were females. So really, the ratio is quite big. So, but I will hope with this initiative we can change that. And of course, in the region, when I think of women who have taken up leadership in arbitration, I would think of Madeline Kimei, who is the president of the Tanzania Institute of Arbitrators. And of course, recently, Kenya appointed Jacqueline Waihenya as the chairperson of the Chartered Institute of Arbitrators. So, and Madeline, I hope you can be on one of our mentorship series. I mean, ladies, there's nothing stopping us from being the future Madeline. So just to list the upcoming activities, we have the annual law conference coming next week, where we'll have a session on the panel. And then of course, this session that we had today, then we have the East Africa International Arbitration Conference. And then in September, we'll have the Nairobi Arbitration Week and also start our mentorship series. So just briefly, this is our team. some of the members are missing here, but yes, with time, you'll be able to find all this information. And just to remind you, yeah, we have a community that has a WhatsApp group. I'll drop the link in the chat. And if you want to reach us, this is our email address for further inquiries. So I hope I've summarized. I'll be available for the Q&A. Ellen, over to you. Thank you.
Wow, Edith. Thank you so much. This is very insightful. At least I'll pick something that, ladies, let's brand ourselves. Let's get out there and grab these things. We have the CVs, but we are seated on them. I would like to hear from Miss Madeleine Kime. Miss Madeleine Kime, we want to know the general overview of arbitration practice in your region. How is it that side? You're welcome.
Thank you very much, Ellen. Thank you for the generous introduction, and thank you for moderating this panel. It was very interesting to hear about the initiative Edith has just presented to us. And I think these kind of initiatives are the ones that are going to enable us to forge our way forward and create a mark for the women in arbitration. And so I commend the entire team, the board of the Women in Arbitration Initiative for this particular region. And indeed, Edith is very correct in highlighting that the statistics as they are right now, and if I speak for my jurisdiction, Tanzania, are very, very low in terms of the women being represented, not only at the panel level, but also in membership. As noted in her presentation, and also was going to be in my presentation, was the panel of arbitrators at the Tanzanian Institute of Arbitrators having only 5 women who are on our panel. Now, in order for one to be appointed, selected, and nominated for an appointment in an arbitration, one has to be in a panel for this particular institution. So our institution is modern in a way in that we work with a panel of arbitrators, which is then shared to the parties, the claimant and the respondent, in order for them to pick out a name that would be best suited for their dispute. Now, if a woman, if we only have 5 women to select from, we are very much at the bottom of the food chain in that aspect. And so thank you so much for those statistics, which speak very well as to the situation in Tanzania and of course our region as highlighted. If I'm to come back to the question that Ellen has posed to me, which is really just giving an overview of arbitration practice in Tanzania. Arbitration, as well defined by Edith, is considered as an alternative dispute resolution in Tanzania, and it works hand in hand in the same spectrum as mediation and conciliation, and recognized in our constitution, Article 107. The Arbitration Act, which is a revised edition of 2020, creates the framework for arbitration conducted under Tanzanian procedural law. The Arbitration Act, the 2020 revised edition, governs all arbitrations seated in mainland Tanzania. And so we're separated from our little baby Zanzibar there. They have their own Arbitration Act, which is slightly outdated as I speak to you today. For the mainland, we have this Arbitration Act revised edition 2020, and it applies to both domestic and international arbitrations. This new act is influenced not only by the UNICITRAL model law on international commercial arbitration, but it is also heavily mirroring the United Kingdom Arbitration Act of 1996. It could be a game changer for us, and I think it has tested 3 years so far, and we are seeing that it has been a game changer for the environment in Tanzania. The departures, of course, from the UNICITRAL model law are partly noted in the issues of setting aside an arbitral award on serious irregularity matters, other innovations that were borrowed from the UK, which are not in the UNICITRAL model law, are also noted heavily in terms of its applications. And we're seeing the courts of law work their hand in each of these newly formulated provisions of law that we had not seen yet tested. So the overall trend, if I call it, is that over the years, we're seeing more and more incorporation of arbitration clauses because of this new trust and confidence in the system. So a valid arbitration clause would be upheld in our courts of law, and that gives it that confidence in parties now choosing to arbitrate. So credit should be given to the judiciary and, of course, the Tanzanian government for implementing these reforms that we have seen that have sparked acceptance, application, and usage of arbitration. A good way of seeing this in reality would be the statistics. For example, the Tanzania Institute of Arbitrators saw its caseload increase by 14 cases. I have not seen that happen since I joined as a member at the TIAB. And so this year we saw a 14 case increase from the previous year, and approximately to the value the disputes being administered to the value of, I think, if I recall, $4.1 million. That is a colossal growth. There has also been a proliferation of arbitral institutions in Tanzania. This may be through the promotion of these new reforms that have happened. We've seen more institutions come into play. TIAB, Tanzania Institute of Arbitrators, being one of the oldest, along with the National Construction Council, providing for construction-related disputes mostly, but also does some commercial administration of commercial arbitrations and adjudications. But we've seen others spark up, such as the Tanzania International Arbitration Center, which opened its doors in late 2019. We've seen the AQRB, I call these architects quantity surveyors. I think they've got their own board, and they do maintain a list of a list of arbitrators and adjudicators to work through that particular body. We've had initiatives being brought into plan by the Tanzania Chamber of Commerce, Industry and Agriculture, the TCCIA. They're not operational, but we've seen that there's this awakening call for more and more institutions to be given life in terms of administering arbitration in the country. And so this has created somehow a little bit of a confusion in the country, because we now have a growing list of institutions with no data to back up those institutions and what they are doing. Of course, as Ellerman says, and I like to quote him because I've noted it in my notes, is that he says that institutions play a critical role. And he goes on to say that with the vast majority of users relying on institutional rules rather than ad hoc or their own tailored procedures, the impact of arbitral institutions on the efficient dispute systems designed cannot be understated. So arbitral institutions synthesize and codify best practices in the industry through a process of intellectual case fertilization with users and practitioners, largely driven by institutional competition among institutions and jurisdictions more generally. So we're not saying that we should not have this growth in the number of institutions, but these institutions need to play their part in creating this synthesis and codifying these best practices in sort of an open door policy, so that we are able to tap into their expertise and their knowledge. So we've been in operation for this new regime for the past 3 years. We are witnessing the courts of law being approaching arbitration in a pro-arbitration manner. This is very much welcomed, as I said earlier. The Act, however, is applying retrospectively under Section 96 of that Arbitration Act. It specifically says and expressly provides that the Act would provide retrospectively. This, of course, has brought in a few issues because a new law ought to be prospective, not retrospective in its operation. And we've seen challenges come to arbitrations that were conducted under the old regime that are now being conducted under this new regime. And especially when it comes to the enforcement of the award, things cripple up. Such as the issue of accreditation of the arbitrator, which is now required under the new law under Section 88. And so we've really witnessed a new breed of practice in our country, and it requires more experiences and more lessons learned for us to be able to say we're at par with our mirroring Arbitration Act of the UK 1996. So this overhaul has demonstrated a commitment by our jurisdiction towards building a preferable seat of arbitration in the region. One note, of course, before I hand over to the next speaker, is that we do not have a specialist arbitration court. All these precedences are being built by the judiciary and more so from the commercial court, which is more familiar and very supportive of arbitration and the law evolving around arbitration. And we've now seen the judiciary's reactions to certain issues. For example, a recent case of the Higher Education Board, which outlined the procedure of filing a domestic award under Section 83 of the Act. That particular Honorable Judge Nangela provides now at least a more streamlined process for practitioners, for arbitrators to know on how to file an award in our courts of law, because at this present moment, our enactments have slightly derailed from this issue in terms of providing conflicting terms from the regulations to the main legislative piece itself. And so we are seeing the courts work their hands through this enactment. Now, just to drive through from an international perspective, Tanzania is also a member of the New York Convention. As we know, this is what gives arbitration its teeth. In order for you to be able to facilitate enforcement of that arbitral award, you'd be much more safer where that country or that state is a member of the New York Convention. And we've got Section 83 and of the Arbitration Act providing for these provisions from the New York Convention. I wouldn't want to mention all of them. We're also a signatory to the Tanzanian, the Tanzanians are also signatories to the ICSID Convention. This ICSID Convention we've been signatories of since 1992. And as an agreed state, there are possibilities of having that ICSID award automatically enforceable as provided for under that under that ICSID convention under Article 53 of the ICSID Convention and 54. And so it is regarded as a final judgment of the state court. And as a member of the convention, we are pretty much tied into those provisions of those articles. Now, we've heard about the statistics in Tanzania. Just maybe to go through them one more time, for the top Tanzanian institutions, which is the Tanzania Institute of Arbitrators, we can say that from its annual report in ending 2022, the membership growth of 277 members, out of those consisted of 74 women and 203 men. And so this is where I was highlighting that it's not only just the panel, but also the membership. But the good news is that in 2023, we did see very encouraging numbers from the new entrants. The new entrants, we had a very good balance. 10 men came in as new members and 12 women joined as members. So this is very encouraging for me as the president of the Tanzania Institute for Arbitrators. The National Construction Council has provided no data. This is unpublished data, to my knowledge. This data was shared to me by their officers in 2022, and I noted that they had a panel of adjudicators and a panel of arbitrators. On the panel of arbitrators, they had a total of 58 and only 14 women and of course, 44 men on that panel. Now, the appointment matrix that we see from the other international institutions is not in the public. The appointment matrix, what I mean is that how many women are appointed, how many women are sitting as sole arbitrators or are sitting as a presiding arbitrator or even appointed as a co-arbitrator. So we're yet, and who appoints them? Is it the claimant or is it the respondent? Do off-counsel have a role in appointing women? We do not have this data yet in Tanzania, and I think I speak also for the region. Thank you, Ellen.
Wow, thank you so much, Miss Madeline. That was quite insightful. So much information about arbitration in Tanzania. Well done, well done, well done. You're doing a great job. We hope to pick something from you, especially at Twina Masiko Edith, who is pushing for the empowerment of women in arbitration. Thank you so much, our panelist, Madeline. We will hear from Kenya. That is Miss Eunice Lumala. Please give us an overview of arbitration practice in your region. You're welcome.
Thank you, Ellen.
Is Eunice there?
See me,
okay.
I believe my my camera was acting up. Thank you so much for a wonderful introduction. I am very pleased to be here. I feel completely at home. I am from Kenya, as you've heard. I am part of a group of ladies who came together since 2018 to form the Women in Alternative Dispute Resolution. And I've had a number of people say, why women? Why do you need to have women this and separate women? Why can't men? In fact, at some of our events, we've had men come up to tell us, can we have that women in ADR have a component of men? We are welcome as friends of women in ADR. The reason why sometimes we need sector-specific associations such as Women in Alternative Dispute Resolution is because sometimes we have specific issues that are, well, they are best understood by women and they can best be dealt with and understood by them to help elevate each other in that regard. And I don't need to get into a lot of it, but honestly, sometimes we get into situations where we get professionals who are hardly ever celebrated. At Women in ADR, we find it has been brought a lot of good and encourage a lot of younger women, where we spare time to celebrate those who have come before us, those who have achieved a lot in the sector, and recognize those who are making steps and making contributions in the world and field of and practice of arbitration, and in that, and ADR in general, because ours encompasses all aspects of ADR, and in that manner, we have seen it really grow. and we start from the university level. So we start with encouraging young people right from universities and talking to them. We have webinars, we have meetings and conferences. And now we are looking at putting in place a fund to help train women and bring them up. So I'll probably deal with that later. For now, let me lay out briefly for those who are not very familiar, and I encourage you all, because if you're in arbitration, it means you understand that arbitration is not local. Arbitration is international. That means that you're open to practicing arbitration, not just in our various localities. What our jurisdictions will block us in terms of legal practice, arbitration opens all that, because we have unified rules. We have, there's no specific venue where you can hold a sitting, and we can have arbitrators practicing from wherever they are in the world. And that is the beauty of arbitration. So even at my introduction, I had, I think there's one thing that may be missing in that part, but as we all know, I just needed to bring this out because I don't think it has been mentioned yet. The issue that we have, the African Arbitration Association. So when you're looking at arbitration at a continental and regional level, we must remember that we have that body, and it has very specific mandate with respect to encouraging arbitration among us as African arbitrators, between us and within Africa, so that us as African practitioners, opportunities are presented to us here and also opened up internationally, so that we're able to compete well, not just in our local jurisdictions. We are able to go for the skills we need to do to get to reach wherever we need to, so that we can be very competitive. How is arbitration in Kenya? So Kenya has come a long way from 1914, where we had the first arbitration ordinance. And don't worry, I'm not going to dwell in history, but we didn't follow our English and Welsh mothers in arbitration, because those are really our mothers in arbitration when it comes to where we developed most of our learning and growth in that practice. What we have is the 1995 Arbitration Act, which is modeled in the UNCITRAL model law. UNCITRAL, for those who have not learned about it, I teach arbitration. It's the United Nations Commission on International Trade Law, whose work is to look at ways of improving, unifying international rules with respect to arbitration. So basically, and commercial trade. So basically, we as a country, and I think many other regions around the world, took up the UNCITRAL model, which had been presented, and we took about over 70%, as was required, of what is in the UNCITRAL model law as our Kenyan law. But really, what took Kenya to grow in leaps and bounds from where we have seen 1914, 1995 to now is the Kenyan Constitution of 2010. I think this is one of the most talked about constitution regionally and globally. What it did is it entrenched arbitration as one among the other key alternative dispute resolution mechanisms. And this means that even judicial officers, judges, who hitherto were not very embracing of arbitration, were now asked to consider ADR and the place of ADR, even as they are looking at cases, and give them space and allow parties to grow. Yeah, allow parties to pursue resolution through arbitration if they so wish, and now to enable it to grow rather than diminish it. So we have that in the Constitution. And other than that, we also have sector-specific laws that have allowed arbitration to thrive. We have the Kenya Ports Authority Act, which specifically directs disputing parties to resolve their dispute. That is under Section 68, don't worry about that, by arbitration. We also have the Mining Act and Intergovernmental Relations Act, which refers parties not necessarily to arbitration, but to resolve their disputes in means other than in courts. Now, just looking at our jurisdiction, also allow me to say that I'm very pleased that some of the efforts we made earlier times to train judges and to have judicial champions in arbitration have yielded a lot of fruit. Disputes relating to arbitration are taken often to the commercial and tax division, unless they have an element of employment where they will be directed to the employment division. And we have now judges sitting as officers, arbiters, who are former arbitration practitioners. You can't imagine what a joy that is, because it means that you're taking a case to someone who understands the practice, who understands the rules, the laws, and you're able to be very satisfied in those divisions. But you know how it is with government and public service. Before you just start enjoying the music, someone is already transferred to another division, to another location, and therefore you have to start afresh. So we really encourage all judges to take the initiative themselves and to join any of the existing institutions and advance in arbitration. That makes you even enjoy the work you're doing once you get a matter relating to arbitration before you. Our jurisdiction is also known to be laying ground in terms of development of international arbitration. And I'm very pleased that one of our members of Women in Alternative Dispute Resolution chairs the Nairobi Center for International Arbitration. This center is constituted by way of the Nairobi Center for Arbitration Act 2013, and here's international arbitrations as well as domestic arbitrations. So all of you, I encourage you to look online, familiarize yourself with their rules, and get to know ways you can join our celebrated chairperson, who is Jacqueline Githinji Oyuyo, a very competent arbitrator, chartered arbitrator, who is at the helm of that center, to understand how the rules are and how you can work with the center as an arbitrator. Anyone is encouraged, once you have filled their forms and met the criteria, to join that institute. We have a thriving environment for arbitration, I must say that, because a lot of institutions encourage training in arbitration. So we have the Chartered Institute of Arbitrators. And allow me just to say, in terms of the membership of the institute, I could estimate that we may have about 1256 members, of whom 350 are ladies. And those who are active means you have to pay subscription, both in London and maybe just development levy, would be around 100, 150, so about 150 active ladies. So you see the percentage of women, and you see that trend everywhere, is about 22%. And we are working to ensure that we speak to our ladies to understand why they are not in arbitration as much as perhaps they're in mediation, because let's be frank, arbitration pays more than some of the other modes of ADR. And we're talking about arbitration, we're also looking at party representatives. You are appearing as a counsel in arbitration. So that number is equally low for ladies compared to men, if you allow me. But I must take this opportunity to thank the International Development Law Organization, otherwise known as IDLO. They've always partnered with us as women in ADR, but also they have commissioned a study, a gender analysis on decisions coming from the tax and commercial division to understand the gender gaps. So we will continue collecting data to understand how do we bridge those gaps, break any barriers, and allow women to compete effectively, well knowing that sometimes ladies are held back by other barriers. Maybe you have children you need to raise, but at one point, at my age and at the age of some of my colleagues, you're left with the husband, if you have one, or with none, and time on your hands, and now you're ready to get into the field. Women in ADR, we take that opportunity to reach out to former judges, to other members who are coming in late, and we give them that opportunity to act. I hope I didn't say something that was not very right, Madam Moderator, even as I conclude. But yes, so we take advantage of the differences in terms of timing and reach out to our members. Finally, Kenya is a member of the New York Convention, meaning if you have an arbitration with Kenyan parties, or Kenya as a party, you know that your award can be enforced easily anywhere within UN Convention members. We also are members of the ICSID panel. Madeleine spoke about the ICSID. I don't need to overemphasize. I sit in its panel of conciliators. And the Law Society of Kenya has a very thriving ADR committee, which I have served in the past, and continuously looks at how to bring in everyone, appoints also, it's an appointing authority. The built industry is very thriving as well. And the numbers of women in the built industry, perhaps even lesser than everywhere else. So that even as we are looking at data and statistics and working to break the barriers, we look at the built industry and our members from there and encourage them to bring younger members on board. So like I say, we start from that level of schools. Allow me to say this as I conclude. Even in the courts and the jurisprudence coming from our litigation practice in arbitration, I believe we have taken the lead in terms of litigating matters up to the Supreme Court. There are specific cases. Anyone who may be interested can check with me later. Synergy Industries, Geochem, and one or two others, where new to Aggravate, where we have litigated a concept that is perhaps only known up to now in Kenya only, the doctrine of substantive injustice or substantial injustice, where an arbitral award may be set aside because it is there is possibility, potential substantive injustice caused to a party. So allow me to end there. And I hope I have whetted your appetite to want to know more about arbitration in Kenya and to work with women in ADR. We have been in discussions with Edith, how women in arbitration Uganda and women in ADR Kenya can work together to strengthen this practice across Africa. Thank you very much.
Thank you so much, Miss Eunice Lumala. That was a good explanation about the practice in Kenya, arbitration practice in Kenya. We have, ladies and gentlemen, we have Miss Ida Juma from Burundi. We welcome you to tell us more about the arbitration practice in your region. You're welcome, Ida.
Thank you very much, Aileen, to introduce me. And good evening, everybody. For Burundi, in Burundi, we have the Burundian Center of Arbitration and Conciliation, which is not profits association, established in March 2004, but is not well developed in comparison to other centers in East Africa. We have the panel of 30 arbitrators, including 1 woman, and the center is regulated by the settlement of arbitration and conciliation, which cover the operating rules applicable with regard to conciliation, mediation, expertise, and litigation submitted to the center. So, how about the arbitration procedure? The arbitration procedure is regulated by the law number 1010 of 13 May 2004 on the Code of Civil Procedure in its articles 337 to 370. It's also governed with the law number 119 of 7th June 2021, reviewed the law number 124, dated on 10 September 2008, creating the investment code in Burundi, which is also governs in part the right to arbitration. The Mining Act, dating from August 4, 2023, also allow investors resort to international or national arbitration in event of conflicts. Burundi was also ratified some international conventions and treaties. For example, the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, on May 2014. We have also ratified the Convention on the Settlement of Investment Disputes between states and national of other states, the ICC Convention, on December 5, 1969. We have also ratified the international treaties such as the City Bilateral Investments, which offering protection to investments in Burundi of investors from Belgium, Luxembourg, Germany, Kenya, Mauritius, Netherlands, and the UK. So what are the opportunities for the practice of arbitration in Burundi? There are not many, but there is a promotion of the rights to arbitration, such as the regulation of arbitration by the legislature, the ratification of international convention, and the current presence of arbitration center in Burundi are efforts towards creating an arbitration-friendly jurisdiction in our country. But even if there are some opportunities, we need to improve the strategic framework for the attractiveness and security of investments, external economic operator, lawyer, and the House Counsel, especially those who are local, do not always advise their clients to conclude contract with arbitration agreements. So, in conclusion, I can say that a considerable amount of inspection needs to be done in order to make state parties aware and accustomed to this practice, and the support of the decision makers for arbitration practice remain needed for the arbitration promotion. It's all I have to say. As in my introduction, I say that the practice of our arbitration is not developed in comparison to the other center in East Africa. Thank you for your attention.
Wow, thank you, Ms. Ida Juma, for this information. I hope you were hearing her. I was. Thank you so much, Ida. We have heard from the countries that we invited today, from the panelists from Kenya, from Tanzania, from Burundi, and from Uganda. Thank you all for giving us an overview of arbitration practice in your different regions. We are going to go to our other session of understanding the benefits of gender diversity and strategies for women empowerment in arbitration space. And this will be discussed by Dr. Teresia Numbi. She's part of our panelists who has been who is also from Tanzania. Our dear doctor, are you there?
Yes, Helen, thank you very much. Yes, it's very, very interesting to hear all that experience, and our knowledge is very something that we wanted to hear. So on my end, to start with, I will start by a statement from a very prominent author when it comes to gender diversity. That is Benjamin Franklin, where he say that if everyone is thinking alike, then nobody thinking. And why did he say that? Is because the broader panel of thinkers instill perspective in a different point of view. And not only that, it's also facilitate or promote a new argument as well as a new perspective of thinking. So according to him, he also has an idea that when he say that it's also bring different skills and experience to a decision in the table. That means when the gender is very considered, there will be a very different outcome compared to a male-dominated sphere. So according to what Franklin was also saying, it's also very important to, as we embrace the modern world, which call for gender diversity, including arbitration, whereby it's not just a matter of ethical imperatives that gender diversity is very important, but also it acts as a strategic advantage that enhance the equality and effectiveness of professional endeavors. That means women should also be given an opportunity to take lead in arbitration. And not only that, when we talk about gender diversity, it's also call for empowerment or to encourage or to break down traditional barriers that women cannot fit in the arbitration space, which is mostly and mainly male dominated, but it also call for canceling biasness, whereby in some instances there are some unconscious biasness that women cannot take part equal as men in the arbitration space. Not only that, it's also a call for dismantling preconceived notion that that women cannot take a similar role as male counterpart can do. And not only that, when we talk about gender diversity, it also has its root from under international law perspective, of which I can take you back in 1979 through the Convention of the Elimination of All Forms of Discrimination Against Women. In 1979, there was a call that it was very important to have women empowerment and inclusion of women for all state parties, as well as whoever was part of it, that it was important to make sure that there are initiatives that encourage gender diversity, as well as to include women in everything that they do. Not only that, the ideal of gender diversity under international law can also be borrowed from the United Nations Sustainable Development Goal, where objective number 5 do call or remind us on to achieve gender equality and empowerment of all women and girls in order to recognize the UN Sustainable Goal. But not only that, this one was also very supported in 2015, whereby there was a committee held under CEDAW, which adopted a recommendation which call for a recommendation that there should be women access to justice, which call or remind states to comfort and remove barrier to women participation as professional within all bodies and levels of judicial and quasi-judicial bodies, as well as activities. This all include or justify that gender diversity is also very important in arbitration space. Not only that, recently we have seen some development, of which I don't have one from Africa, but we can borrow from a gender chapter, which was introduced in the Canada-Chile free trade agreement, where for the first time, they were able to include a gender clause that whatever they're doing, that they should respect as well as adhere to the gender requirement in the investment agreement. But not only that, the call for gender diversity is also being reflected even in East Africa, whereby according to our East Africa Community Gender Policy, of 2018, it also call or provide a framework where gender is something that is very important. It needs to be considered for the matter in every matter that partner states are encountered. Not only that, it's also very important to remind ourselves, are there any challenges that are faced in relating to women in arbitration, regarding to gender diversity. So from my end, I have some few challenges that I've come across. One among them is that the idea of underrepresentation, whereas women are often underrepresented in arbitration panels, which can lead a lack of diversity perspective in decision-making process, which is very general. Not only that, as one of the presenters said, working life balance can also be a challenge, whereby balancing arbitration commitments with family or personal responsibility can also be a particular demanding when it comes to women, hence a little bit hinder the availability as well as progression when it comes to arbitration compared to male. Not only that, there's also a notion of implicit biasness. When we talk about implicit biasness, it's also based on our perception that women capabilities or potential of them to handle a similar issue as men, which even if we're in our 21st century, but the same idea still take us back and we don't fall. And not only that, there's also another big challenge that face women in arbitration, talk about gender diversity, is the idea of lack of role models. Yes, we do have role model. Like if you ask me today, modeling has been always my role model, but the ideal of modeling, there are very few. So some other people fail to get their own modeling to look upon, of which it acts as a challenge to some of them. And not only that, there's another challenge that you should also, we can also deep dive, the idea of confidence and self-advocacy, whereby women face challenges in ascertaining themselves and advocating for the expertise potential affecting their participation and leadership role. So when we talk about the idea of challenges that are facing women in arbitration, which also act as a setback for them to get a seat in arbitration. There are many, but from my end, those are some few. And as Ellen said, I should also talk about the benefits. Are there any benefits relating to gender diversity in arbitration? The answer is yes. And the following are just a major benefit. One among them is gender diversity call for neutral and fair proceedings. We all know that gender diversity panel help counteract biasness, which it has been a debate as well as a call that we always feel that we are not well represented or female are not well represented. So through having gender diverse, it can easily correct and as well as allow neutral and fair proceedings. Not only that, it also call for representative of all stakeholders. Talk about this one is also very interesting, by gender diversity ensure that the interests as well as concerns and experience of all parties, male and female, are involved and are taken into consideration, resulting to a more holistic and inclusive arbitration proceedings. And not only that, we also have the idea of innovative solution, whereas diversity perspectives always stimulate innovative thinking, as well as create creative problem solving, as inclusive different point of view can also lead to the discovery of new solution to resolve several complexity that associated in arbitral panel. Not only that, there's also other benefits that are worth mentioning. Some of them, these also include expanded expertise, whereas a diverse panel bring a wide range of expertise as well as background, can enrich the understanding of legal and industry specific matters as per arbitral proceedings which takes place. Not only that, It also in line with the global advocacy for gender equality, whereas promoting gender diversity in arbitration align with international efforts for gender equality and our women empowerment, as well as contribute to the broader legal and societal progress, whereby everyone in the world, they do advocate and encourage gender to be considered. And lastly, one among the best benefits of gender diversity in arbitration is also act as inspiration and role modeling, whereas female arbitrators serve as the role model, inspiring others women to join in the field and contributing to a pipeline of advice and qualified arbitration profession. Again, I'll be biased for this. Madeline has been my role model since day one. And everything that you see, I'm borrowing or trying to imitate from her, because somebody as from Tanzania, somebody that we do look upon when it comes to arbitration matters. And again, it's also very important to try to deep dive also to understand, are there any actionable strategies for women empowerment in arbitration space? The answer is always yes, whereby gender equality, what need to be done? From my end, I do insist that there should be gender equality clauses, whereby arbitration agreement and clauses can be tailored to encourage diversity arbitrators appointment, contribution to the broader advocacy for the gender equality. Since we're going to have at least a legal document that remind parties to have or to consider gender even in the negotiation, as well as part of the process of arbitration, we can easily correct as well as encourage gender diversity into action. Not only that, we should also have a capacity building for women in arbitration. And how do we do it? Our first presenter made it very well, whereby we need to have workshop, webinars, training programs, initiatives which are organized to provide women with skills and knowledge needed to excel in the arbitration field. Not only that, other strategy that can also assist us is on the idea of conducting a periodical survey on domestic and international arbitration. Why doing this? This will assist us in shedding light on gender diversity and disparity in the field, thereby encouraging and remind member state or individual to take action. I'm sure when you do a similar survey next year, there might be some progress, or there must be something that will give us something to move on, as well as to have tangible results to explain. Not only that, another strategy that I think need to be on board is that, as the previous speaker said, we need to recognize and celebrate the achievement of women in the legal and arbitration sector, so as to provide visibility and inspiration for women pursuing career in arbitration, of which I'm sure we have started it, but let us give more room for that, so that we know each other as well as we celebrate each other. And another thing that I also see as a strategy need to be taken on board is on the idea of collaborative partnership. And I talk about collaborative partnership is among the arbitration institution, legal association, academia, advocacy, bar association, and any other. Once we combine or we join hands, we can easily encourage as well as advocate for gender diversity in arbitration. And not only that, there's also other things that we can also do. One among them include supporting women initiatives that are on board. There are several women in ADR initiatives that need a push, or need a commitment, or need to be more supported. So we need to support those kind of initiatives so that together we achieve a common goal. And another initiative that it need to be taken, another strategy that we can also borrow, is that institutions should give more to female arbitrator and convert convince corporate client that even female arbitrators have a similar talent as well as potential to do or to act as male arbitrators. So once we prove to them that we are capable of doing that, they can easily support as well as prefer female arbitrators. And another thing which is also want us to end is, from my end, is that selection of arbitrator should be based on their resume. That means we can also adapt the idea of having a blind resume whereby you don't put the name, because by putting the name, they can easily identify this is Ida or this is Eunice. So they can easily have a blind resume whereby party can easily select. This will also assist us, or will also eradicate bias. And sometimes you can even encourage parties that female arbitrators can also secure the same spot as male. And lastly, ending in my presentation, I would like you to leave a quote from Henford, where he say that if everyone is moving forward, then success take care of itself. This is very important because in respect with the diversity, it could be said that only general awareness and common action may result in a positive outcome. And to achieve great diversity, also all the actors playing in the field must act together. So if we act together as arbitral institution, law firm, bar association, several initiatives that encourage or advocate for gender diversity, we can easily achieve involvement of gender when it comes to arbitration space. And that is it from my end. Thank you.
That was smart and comprehensive, Dr. Numbi. Thank you so much for the presentation. We have picked so much from the presentation, especially about the benefits, the barriers, and the strategies that we need to follow or we need to adopt in order to be part of the women in the arbitration space. Thank you so much, Dr. Numbi. Teresia, that was nice. That was very smart presentation. We have, I'm inviting our next speaker, who will be Miss Madeline Kimei, and she'll be speaking to us about what the future of arbitration for women looks like. Is it there? What is happening? What does the future of arbitration look like? Thank you, Madeline. Let me also say something. I love the way everyone is referring to you as a powerful woman in the arbitration space. Kudos to you.
Thank you, Ellen. Thank you, Dr. Teresia. Thank you so much. It really is humbling, and I do see you and we do see each other, and I compliment you equally for the very short span work that you've been doing, but it has been really an elephant sort of effect in the fraternity, and we recognize that very much. So thank you so much. Very humbling, and as Ellen has pointed out, a very good presentation indeed. So thank you, Ellen. Future of arbitration. This is it's not a very difficult one after hearing the presentations that we've heard today, coming in from Kenya, Uganda, Burundi, and hearing the benefits of the involvement of the woman in arbitration, and realizing the woman in their space in arbitration. And so my presentation with regards to the future of arbitration is really just to highlight 4 issues which I noted down prior to our session today. One is recognizing that the statistics are very encouraging. From a global scale, they're very encouraging, and we're seeing a shift. And as I think it was Eunice highlighted, is that arbitration is an international practice. You cannot create a border if you're going to span out in the practice of arbitration. And so it's international in its true nature. And so from a global scale, we're seeing this shift in the gender balance. And I'm very much optimistic of what is going to happen, because I think it is going to remain positive. It will be a positive change moving forward. And the data that is reflecting in the institutions, the international institutions that I will speak about in a moment, it is going to reflect here. Of course, it might take time. It will not be instantaneous, but it will trickle down to the region. As I have said, predictably, that will happen in the near future. For the institutions that I looked at, and in terms of investment arbitration, remarkably, there has been poor record of representation of women in investment arbitration. And so I went back to the statistics. I like working with statistics. So I looked at the 2022 caseload report that was issued by the ICSID. And it goes on to show that women accounted for 23% of appointments to the ICSID cases in 2022. And this is compared to the 27% in 2021 and 23% in 2020. And these appointments, they go on to say, were made by co-arbitrators. 40% were made by co-arbitrators, 60% by men, and 60% by women co-arbitrators. Appointments made by the ICSID were 37% women and 63% being men. And appointments made jointly by the parties were 32% women and 68% were men. And finally, they go on to say that men accounted for 90% of appointments made by claimants and 87% appointments made by the respondents in 2022. So that is the picture that we see at the ICSID. We move on to the ICC, where I serve as a member for the International Court of Arbitration. The 2021 statistics show an improvement from the recent years of the gender balance of arbitrators, with women making up to a close of 40% of appointments being made by the ICC court in 2021. And these figures really do create this attractiveness, or at least positive outlook to what we should be expecting in the near future. The 2022 ICCA report, they created a task force on studying this diversity issue. And they aimed at different stakeholders and qualified women candidates, those who were nominated or appointed as arbitrators, in-house counsels, the lawyers, the funders, the litigation funders or third-party funders, and of course, conference organizers. And that report concludes with and gives us an important reminder, saying that those in the position of making appointments, primarily parties and their representatives, but also the institutions and the co-arbitrators, have the greatest influence on gender diversity in arbitral tribunals. And I couldn't agree more. At the end of the day, it will be the co-arbitrators, it would be the institution's role, and the key players, meaning the legal representatives or the in-house counsels, to ensure that we achieve this gender balance. And so that is still remaining to be a critical reminder to all. I, for one, received my first appointment from the Cairo Regional International Arbitration Center because of the co-arbitrators. The co-arbitrators realized it was a two-man team, and they said, we need to create some sort of balance. And there goes Madeline being appointed as a presiding arbitrator and creating that gender balance on that arbitral tribunal. And so that is an example that we need to learn from. And I think in future, we will be seeing more and more of these efforts being made by not only in-house counsel, legal representatives, but also the core arbitrators and the institutions in ensuring that we gain this balance. Another issue that I see that would be in the near future or probably already happening is the use of technology. The use of technology will continue to push this positivity forward in terms of achieving gender balance. Why do I say this? I say this because technologies and artificial tools, artificial intelligence tools have now come into existence, which aim to provide us with tools on the selection of arbitrators. One such example is the Jus Connect, which is a Jus Mundi affiliated tool. A Jus Connect works similarly to arbitrator intelligence. Arbitrator intelligence gives you the tools to be able to identify arbitrators, do conflict checks, find out from different jurisdictions which arbitrator is English qualified and maybe having also a knowledge of the Chinese language. So these tools are going to help create a much more smaller gap in this diversity issue. I've also seen, and I think in future, these would have worked very strongly in creating this enabling environment for women. Initiatives such as the Women Initiative that we see being Women in Arbitration Initiative presented by Edith. These initiatives, along with other initiatives such as equal representation in arbitration, Mute of Thursdays, I'm a dedicated member of Mute of Thursdays, and Arbitral Women, all these initiatives would really be the stronghold, the foundation for this future that we are very much optimistic of. So they would create this renewed impetus of the change in diversity in arbitration. And we see the growth of them, we recognize the growth of them, and as women, we should play a role in embracing their existence and playing a part in these initiatives that are being put in place. Now, those were the 2 or 3 main pointers on the future of arbitration that I wanted to share with you today. And I hope I can end there and pick up on any questions, because I know time is not on our side. So thank you very much, Ellen.
Thank you so much. Thank you so much, Ms. Madeline, for that presentation about the future of the women in arbitration. I think I can sum it up by saying that that will come for those that have information about the arbitration practice in our different regions. And we were already told by Eunice that arbitration is international. So it is not something that will only work for you in your region, but globally. Thank you so much, Madeline. That was very, very, very insightful.
Thank you, Ellen.
Yeah.
It's very true. It's very true what you say, that information is key. And so increased transparency that we spoke of earlier through reporting, standardized reporting by institutions, that would increase the information that will be out there for the women aspiring to build their industry in arbitration. And of course, that information should be very much channeled and intentional to creating the women's aspiration towards this field of practice. So indeed, information is very much of utmost importance.
Thank you, Madeleine, for those for that information. We will have 5 minutes given to Edith to present to us the initiatives, which initiatives are out there for us to join, for us to actually access, and how do we actually join them. Edith Twinamasko, are you there?
Yes, thank you, Ellen. Okay, so Madeleine in her presentation already alluded to all those initiatives, the equal representation in arbitration, the pledge that started in 2015. So it has over 5,000 signatures. So I've also put my signature to it. So I urge all of us, I think the first step is to sign the pledge and advance the fight for diversity in arbitration. And as well, she also talked about Arbitral Women, which is based in the UK, and of course, Women in Arbitration Initiative, which I started this year, as well as Women in ADR, which is in Kenya. All those are really pushing for diversity in arbitration. So I don't want to waste much time because I see it's really spent. I'll just end with this. I don't know, in case there's no time for parting shots. So when a bird wants to fly, it starts by flapping its wings. So ladies, I think we should also take the same initiative. If we want to soar, let's take initiative. Let's take a step, to better ourselves in all aspects, and then we'll get these opportunities in arbitration. Yes, and I had already shared our contact information. In case you need it, you can just type in the chat and we shall share it again. But thank you. I don't know, I've summarized because I really see that we're out of time, but thank you so much, and to all our panelists. Over to you, Ellen.
That was fast. Thank you, Edith. I will thank you for sharing that information, but I want to hear from Eunice. Eunice, are you there? I'd like to hear from you about the initiatives that are in Kenya and those that we can tap into, and especially who are these prominent women that we have not heard about in this space. Thank you. Eunice? Eunice, are you there?
Hi, I'm back.
Okay, please take up your space.
Thank you. Right, so I'll start by saying this, that, you can achieve much in your own space and practice. If you're in your own corner, maybe you won't reach far. The reason of coming together and forming initiatives that can understand women's specific realities and supporting them to grow together is because of realizing that networking is key in your growth in the space of arbitration and ADR in general. ADR is very specific. You cannot appoint a law firm. You appoint Eunice Lumalas as an individual. And once you do, that means that I take individual responsibility. Therefore, issues of integrity are very important in arbitration because it is person-specific arbitration. Now, in 2016, the registrar of ICSID panel came to Kenya, and she was teaching module 1 and 2 of ICSID law. And so we were asking, why don't you appoint women in arbitration, or even Africans? Why don't Africans get appointed a lot more in the panel? And her answer was very profound. I think she answered innocently. She said, but in the appointments that we do from the registry, the secretariat, we appoint people that we know. So if we don't know you, how will we appoint you? So coming together in initiatives such as the ones that Edith and myself and others, Arbitral Women, she's in France, and others do, is because we understand the centrality of positioning women. In fact, for us, our motto is positioning women in alternative dispute resolution. We have to position you to be ready to take up the positions that you aspire to when they present themselves. That is why networking has been key. We try, and we don't try, we actually do put together networking events and create spaces for our members to join in arbitral panels. We encourage them to attend conferences because, like I said, if somebody doesn't know you and you are so good in your own corner practicing, what good will that serve you? You must get out there. We have started a newsletter, and soon we are going to publish, and we're also encouraging publications by our individuals in academic journals, among others, so that people can see you out there. And that's how you sell your name. Now, what else do we encourage? We encourage initiatives relating to mentorship. Mentorship means that you look at Dr. Teresia, for example, and say, oh, I admire how she works. And so let me tell you something. In the space of arbitration, your experience is important. Sometimes you can't always get appointed individually to start, particularly in international arbitration briefs. So what you do, you identify someone who's already thriving in the field and seek to work with them to learn the ropes and grow in your practice. So you have to identify a mentor and work with the mentor, be committed. So that's what we have. We have an elaborate mentorship program, which our members are part of. Something else that I wish to add.
You have 2 minutes left.
Okay, something else that I may just need to add in brief is that, and maybe that's to everyone who is young, and I've seen a comment of two saying we want to get into this. We are open to and welcoming all of you. We are putting together a fund because, let's be sincere, sometimes it's expensive to pay for arbitration training, to pay for your subscription to the Cairo Center, to KIAC, and other centers around where you may want to get international appointments. Therefore, we are working to have a revolving fund. That's one of the key initiatives we're having, so that women have access to that money when and as they need it, to attend conferences, to pay for their studies and get the qualification they need so that they are ready when the opportunity presents itself. I thank you very much.
Thank you so much, Eunice. That was very insightful. Ladies and gentlemen, I am going to open the floor to the participants to ask questions. In the chat box, we have thank you messages. People are thanking the presenters for the presentation, and also asking if the information that is here will be shared. The recording will be shared. I think arbitration seems costly as IAC. What would you do to make it less costly? This question, anyone ready to answer this question? Arbitration seems costly as East African community. What would you do to make it less costly? We have heard from Eunice. She has talked about the fund that is being organized. Can we hear from someone from the East African? Are we there? Hello?
Yes, we're here. Alan, can you repeat the question?
The question is, arbitration seems costly as the East African community. What would you do to make it less costly?
Thank you. Yes, I did get you. And just maybe to chip in so that we can allow the other panelists, and I'm not going to put on my video, apologies. So arbitration being costly is really an issue that has been discussed in many doors. in many closed doors. Why would it be costly? It should be your question. Why is arbitration costly? I think the first thought that comes to my head is usually why I would find an arbitration becomes costly is the arbitrators and the party representatives not being competent in arbitration. That would be the reason why an arbitration could ensue to be costly. Why do I say this? I say this because you may find that an arbitration of low value and the arbitration being of low value, you have a panel of 3 arbitrators being appointed to that low value arbitration. Councils have not discussed means of trying to reduce the cost by maybe agreeing to a sole arbitrator. Why they've not discussed this? Because they do not understand or grasp that this can be done, by agreement of the parties. And this is an issue that we're facing in Tanzania very much. So the arbitrators not having a schedule of fees is the other issue, why it could be expensive. Some institutions have now recently introduced schedules of fees, the Tanzania Institute of Arbitrators being one of them. In our new TAB Arbitration Rules 2022, we introduce as a schedule a fee structure that can be utilized by arbitrators, arbitral tribunals, and the parties in negotiating the rates of the arbitrators. And so that's something that we're seeing that could help in at least creating this regime in terms of costs of arbitration in the country. So the arbitral institutions are playing a role to ensure that the arbitrators have some sort of a schedule to rely on of fees or a band that can be used. And then of course, the parties' representatives themselves need to understand that certain disputes or certain value levels of disputes could be flexibly approached in a way that could be cost efficient to the parties. I hope that sort of just triggers more food for thought for the person who asked the question, but also his concern or her concern gets me to also the thinking of why we're seeing mediation, commercial mediation span out or continue to grow because of this negative thought of arbitration being more expensive due to its procedural, the way it is procedurally frameworked. And so our mediation is now becoming more acceptable as practitioners and parties in the space see it to be more or less costly in that light. So it's something that—
Thank you so much. Thank you so much.
Ellen,
Unfortunately, our time is up. Our time is up. I want to thank you once again, our panelists, for the powerful and insightful presentations. Thank you all for being part of this webinar. As for me, my time is up for this webinar. I thank you so much. I thank you, the presenters. Eunice, did you have something to say quickly?
No, just to thank you and to emphasize that arbitration is not really costly. I would see it mostly as cost effective rather than costly. And if an advocate maybe does not have, and he's representing a party and doesn't have the skills necessary to know how costs can be capped, for example, then they may not be able to effectively represent their clients. I encourage everyone to study so that you can effectively represent your clients if you're an advocate. And many institutions, they actually allow you to pay for your classes in installments, such as the Chartered Institute of Arbitrators, Kenya. So this is something, if you have the interest, go for it.
Okay, parting shots from Ida. Miss Ida, do you have something to tell us as we move on? Hello, Ida.
Sorry, I didn't catch you very well.
Parting shots, anything to tell us as we finish up this webinar?
I can say that I can ask to the women arbitrators to serve at the table as do the men, and can ask to the institution promote women arbitrators. So I can finish to welcome you in the next ELS annual assembly, which will be held on Burundi on November. Karibuni sana.
Thank you so much, our dear panelists. The questions that are on, people are requesting for the presentation. Over to you, Gabriel, about the presentation. Are you there, Gabriel? Are people getting this presentation? The recording. Okay. We will work with Gabriel to see how this recording gets to the people in the chat box that are requesting for the same. Otherwise, as for me, I am delighted to have been your moderator today. Thank you so much for insightful and smart presentations by dear panelists. And this concludes our discussion. Asante sana.
Asante sana, asante Ellen. Thank you for this well-moderated session. I really
Thank you,
enjoyed.
Ellen. Yes,
Thank
I agree
you.
with Madeline. Yeah, thank you.
Thank you, thank you.
Thank you, Ellen.
Let's continue broadening the dialogue. See you all. Thank you.
Okay.
See you.
For sure.